Right, good morning, everybody. We are delighted to see so many of you joining the session today. I hope you will find the presentations and discussions to be useful and informative. My name is Reuben Taylor QC. I'm a planning specialist at Landmark, and I'm going to chair the session today. I'm going to begin with a few housekeeping points, if I may. Firstly, your microphones are all automatically muted, so you shouldn't need to adjust your settings locally. We very much welcome questions throughout the session. You should be able to submit them via text in the Q&A section on your screen, which is found either at the top or the bottom of the screen. We'll do our best to try to answer as many questions as we can by the end of the presentations, but if we're unable to do so, we'll follow up after the event. If you do lose your connection at any point during the presentations, please just rejoin the meeting by clicking on the original link that you were given. Okay, I'm going to begin then. So what has occurred in recent weeks in this country has obviously placed very significant demands on all of us. Some difficult, some amusing. My favourite story so far is of a colleague in full flow from her home office making a submission to a judge via a video link when her son came in singing Rick Astley's Never Gonna Give You Up at full volume. Happily, it turned out that the judge was a bit of an 80s fan. But it's not just working from home that's challenging. The machinery of local government has suddenly found itself facing the need to comply with its various public duties and obligations across its wide purview in a socially distanced world, from rubbish collection to social services and child safety to planning decisions and homelessness applications. The legal, social and financial constraints that local government faces are now extremely daunting. And so this webinar seeks to look at the legal framework for local authority decision making and how it can and is being adjusted to address the days ahead. We've got three presentations for you today. We have one from Jacqueline Lean, who will be looking at the existing legal requirements in relation to decisions made in committee and under delegated powers and how councils have been adapting to the social distancing requirements. We also have Yaaser Vanderman, who will be giving the second paper looking at the regulations which have been made under Section 78 of the Coronavirus Act 2020 to allow for virtual decision making. He will be looking at the illegal implications of those regulations, in particular with regard to councils' constitutions. And lastly, you'll be hearing from Jenny Wigley about the practical implications for and the risks of making decisions during this emergency period. So with that, we will then end with the Q&A session where we will switch to video mode and you can watch us all trying to look calm, collected and knowledgeable as we attempt to answer your no doubt difficult questions. I'm going to start then with to introduce Jacqueline Lean. Jacqueline has a broad practice encompassing property planning and environmental and public law. She acted for the Department for Transport in respect of High Speed 2 Phase 1, both in the litigation and as part of the team promoting the bill through Parliament. And she's also acting on that project through Phase 2A through Parliament. She's on the Treasury panel, and she's been described in the Legal 500 as standing out for her versatility and fierce intellect. Jacqueline is addressing, as I said before, the existing legal requirements for local authority decision making and how councils are adapting to the present crisis. Jacqueline, over to you.
Thank you, Reuben, and good morning, everybody. As Reuben mentioned, I'm going to just try and give a bit of an overview of the legislative framework that really sort of sets the starting point for considering what restrictions or controls there may be on the decisions that need to be taken now about how to discharge functions and how to deal with decision making in this brave new world in which we find ourselves. And just by way of a very broad overview, the legislative starting point is really in parts 5A and 6 of the Local Government Act 1972. We also need to look at parts of the Local Government Act 2000, and then critically, and this is where it becomes obviously quite case by case, for any individual council or body, what's provided for by the Constitution, what's provided for under the existing scheme of delegation, and what needs to be looked at in terms of standing orders for how changes may be made or processes that may need to be followed. So turning first to the 1972 Act, I've just tried to highlight a couple of key provisions that are engaged here. Obviously, sections 100A to 100K, which deal with public access to meetings and information, have now been addressed to at least some degree by the 2020 regulations that were published about a week ago. I'm not going to say any more about those really, because Yaaser will be covering those in rather more detail in his talk. But also to highlight that what we get then in part 6 are the arrangements for the discharge of functions, the provisions about delegated committees, and the power to make standing orders. Sorry, just before moving on from that slide, but I've moved on and can't work out how to go backwards, I'm afraid. It's worth obviously noting that the power in section 101 is quite broadly expressed in subparagraph 1. That's the ability for a local authority to arrange for its functions to be discharged by a committee, a subcommittee, or an officer of the authority. And in subparagraph 2, where a function can be discharged by a committee, then unless the local authority has directed otherwise, the committee can arrange for those functions to be discharged by a subcommittee or by an officer. So that's the starting point there. As I said, what are going to be the really critical documents to look at this time are going to be the council's own constitution and the current scheme of delegation, because obviously whilst there's quite that general power in section 101, exactly how that has been exercised and what can or can't be done in any given case, the answer to that will be found in the constitution and the scheme of delegation, as opposed to the broad legislative provisions on a case-by-case basis. Sorry, I've just managed to click off the screen. Forgive me a second. So in terms of discharge of functions and decision making and things that need to be looked at, I've mentioned section 101. I've mentioned section 101 subsection 2. Obviously that doesn't apply to executive functions where there are executive arrangements in place. For that, we have to look to section 9E and specifically of the Local Government Act 2000. I tried but couldn't work out how on earth I could summarise that accurately yet concisely on a slide. So it is worth looking at the provision in its entirety in terms of what exactly can be done with those arrangements. And in short, obviously, that provides power in particular to the senior executive member to discharge executive functions or arrange for discharge of those functions by other members of the executive or by a committee or by an officer, as the case may be. And obviously an important aspect to bear in mind is that any scheme of delegations that will cover all those aspects is required to be published under section 100G of the 1972 Act. So as I said, that provides the broad picture or the broad framework from looking at the situation of, well, what can we do now? What changes can we make? And I've just tried to highlight a few things that I think will probably need to be thought about in any given case. Firstly, where you have functions that have been delegated to committee, under section 101 of the Local Government Act 1972, or have been delegated to subcommittee. One thing that needs to be considered is if this is going to have to go ahead by committee meeting, because there's not scope, for example, to delegate that particular function, or it's not consistent to delegate it with the council's current procedures. What is the quorum? What's the minimum number of people that you need to have in your virtual meeting in order for a decision to be lawfully taken? And obviously, to some degree, there's some requirements around that in the legislation. It's broadly a quarter for full council meetings, and it's often a third for committee meetings. But again, you need to look at the specific standing orders that apply to any given local authority on that. So particularly in this age of having to work by video link and thinking about the numbers who absolutely have to be in on meetings, quorum is something that can't be forgotten, because clearly, although the regulations make provision for meetings to be held remotely rather than in the same room, I don't think those are going to be a get out of jail free card if there's any issue raised about the lawfulness of a decision taken remotely, if in fact the meeting has not been quorate under the council's own standing orders. Secondly, what needs to be looked at is what scope, or what further scope there may be for delegation to officers of different types of decisions. And this may be particularly relevant in the planning context, because there's obviously quite a lot floating around the Ethernet at the moment around different decisions and different things that are being looked at by different local planning authorities. And certainly there's been some very useful guidance that was issued by the Planning Officers Society on the sorts of decisions that might be suitable, or more obviously suitable, for greater delegation to officers than others. So again, that needs to be looked at in terms of the procedures that have to be followed if the delegation arrangements are going to be changed. Because as we know from the Hethel case, a 2010 decision of the Court of Appeal, yes, local authorities may be able to delegate, but if they don't follow the specified procedures for lawful delegation, then you're probably going to have a problem with the decision. In terms of executive functions, as I've referred to, there's obviously the powers of the senior executive member to discharge or arrange for discharge of executive functions under Section 9E of the Local Government Act 2000. For Mayor and Cabinet, that's the senior executive officer is the Mayor. For a leader and cabinet executive type arrangement, it's the leader. So there may well be some flexibility there for handling those sort of executive functions or decisions at the moment, particularly delegating it around those to whom those in the cabinet or officials, to try and lighten the load slightly on any one individual. But again, it's going to be important to check that any decisions to change decision making, who the decision making rests with or how it's being done, is compliant with the council's own internal constitution, delegation, standing orders. Final thing to think about is emergency powers. Often a number of constitutional arrangements will have a provision for decisions to be taken or decisions to be made as to how decisions are going to be made or by whom in a sort of quasi-emergency situation where maybe the usual proceedings can't be followed. Obviously, it's important to look and see what the specific provision is within your own constitution or standing orders. To see what flexibility that may provide for dealing with things, particularly if they come up, their matters that need to be dealt with urgently or quicker than usual because of the nature of the times we find ourselves in, and it's not possible to just, for example, wait for the usual period of time or the time to convene a full remote meeting. So those strike me as being sort of in broad terms the three key areas that need consideration at the moment. Standing orders, I've referred to section 106 of the 1972 Act, which is where the power is to make standing orders to deal with council business or procedures. So members, voting members, processes, things like that. The 2020 regulations obviously do make some provision for standing orders. I know that Yaaser will be touching on this in his presentation. but it's important to bear in mind that whilst Regulation 5 might provide some scope for override or departure from council's standing orders in the context of remote meetings, it's not, again, a complete get out of jail free card in respect of other procedures or other requirements of standing orders. So it seems to me that probably a fairly critical action in, well, that's a difficult thing to say in an era of where every action is no doubt critical for local authorities, that a key matter to check will be the existing standing order procedures to identify where there may be conflicts between the practical way that you're having to work at the moment, or the changes you're going to have to be making to allow for the remote meetings, to check what conflicts or prohibitions or restrictions there may be that aren't sort of dealt with by the provision that's made in Regulation 5, the 2020 regulations, and where necessary to consider amending those standing orders as a matter of priority to make sure that you can carry on business in the way that you need to do so. And again, clearly a critical point to check there will be, what is the procedure you need to follow if you want to amend standing orders? Sorry, I don't know how to go backwards. I've jumped a couple. Oh, there we go. So just by way of summary of the points I was making a few moments ago, some practical points to consider. Firstly, and I'm sure this is something that's already under consideration for a lot of authorities, is what is the scope for further delegation? What procedures have to be followed if you want to authorise those further delegations? And are there any specific restrictions either in your own governance arrangements or in the wider legislation as to decisions that can or can't be delegated, and by or to whom? And I do touch on in a moment a couple of specific areas to think about, but one point to bear in mind here would be, for example, powers of licensing committees and the statutory guidance that's been issued in respect of delegation of licensing functions. And obviously some things would not seem to be able to be delegable, it seems to me, are functions, for example, of scrutiny and overview committees. It might be difficult to try and delegate those away. Secondly, the thing to think about are any changes to standing orders that may be required, or new protocols that may need to be put in place to address these different ways of working. And again, things to consider: who needs to approve, or how do those changes need to be approved, and also what needs to be covered. And I'm sure that others will say more about this, but there will obviously need to be consideration given in the remote working context, for example, to if and how public participation is going to work, if people are going to be able to speak at meetings, how that is going to be facilitated. So again, it may be committee or area specific, but I think it's, again, no one size fits all properly in terms of what different protocols or standing orders may need to cover. And finally, just a final point to consider is call-in powers. Obviously, again, different authorities will have different arrangements in different fields for call-in powers, either delegate off decisions that have been delegated to officers, say in the planning context, being able to be called into full committee, or executive decisions that are able to be called in to cabinet. Again, it's probably just worth looking at what the procedures are that surround those, to check that if needs to be, those can be preserved. And I have in mind here, for example, I know that some local authorities have arrangements for planning committees that provide for them to be dealt with delegated by officers unless it's concerns are raised by the ward councillor or by the parish council. So that obviously needs to, that in those circumstances, there need to be some consideration to how those people are going to be notified that these decisions are coming up, so that they can try to exercise, ask for that, make that request that would allow that power to be exercised if needs be. I said, just touching very briefly on some specific decisions and functions. One thing to note, some very recent regulations, I think they were laid on the 6th and came into force, made on the 6th and laid before Parliament on the 7th of April. They come into force on the 30th of April. that the deadline for local government finance audits have been pushed back, and those regulations also make provision for a delay to when the publicity period starts for those. In the licensing context, I've already mentioned that this is probably an area where there are some greater restrictions on delegation and how decisions have to be made in the underlying Act, and there's some quite specific guidance on delegation in the statutory guidance on the Act. And also just to note in this context that there has been a very recent letter from Kit Malthouse MP about licensing business going on, and how important it is that hearings in particular can continue during the current times. And I'm very grateful to the Institute of Licensing website, who had a link to it on their website, and hopefully that link should work. If not, it's available via their main website. And just finally, in this context as well, planning is obviously an area that's had a lot of attention by those involved in all aspects of the business over the last few weeks. The Royal Borough of Kensington and Chelsea is holding a virtual planning committee meeting this evening, I believe that is. There have already been some part virtual ones held elsewhere, which have involved a few committee members sitting in the room, but I understand this is going to be the first full virtual planning committee. And also there's already some information in the public domain about greater exercise of delegation powers or emergency delegation powers that have been used in this field by the two authorities I've mentioned there. I think whichever is arguably more you would expect in terms of greater delegation of smaller applications. Manchester has taken a slightly more a slightly different approach in terms of even some larger applications and who can deal with those. So as I said, there is some information in the in the wider public domain about those, and just quite interesting to see the different approaches that are being taken. Oh, and with that, I think we come on to Yaaser, and happy to also take any questions when we get to the end of the presentation.
Thank you very much indeed, Jacqueline. Yeah, we're going to turn to our second presentation of the morning to Yaaser Vanderman. Now, Yaaser was called to the bar in 2012. His broad practice covers public law and human rights, planning and environmental law, and indeed property law. In 2019 alone, he appeared in the Supreme Court in no less than 4 cases, including the recent Lambeth case on the interpretation of planning permissions. He's on the Treasury panel, and Yaaser is addressing the recent regulations that have been passed pursuant to Section 78 of the Coronavirus Act and how they affect decision-making. Yaaser, over to you.
Thank you so much, Reuben. Good morning, everyone. I have to say I'm rather relieved about the lack of video because this lockdown has not been kind on my hair. I don't know who I trust more out of my wife or my 18-month-old daughter with a pair of scissors, but I think we'll cross that bridge when we get to it. I'm going to be looking at the 2020 regs. I won't read out its full title because, well, it will take too long. So I'll be looking at the 2020 regs, what they actually do and how they achieve it. And just a caveat before I begin, obviously these regulations just came out, I think, on Saturday. There's been no extensive discussion about them so far by legal practitioners, and no court has considered them. So it may well be that during the course of our discussion, we touch upon things that shed a new light on the meaning of some of the provisions. I'd also just say it might be useful to have a copy of the regs in front of you during my talk, if possible. You can copy and paste that wording, put it to Google if possible, or just get them up some other way. I'll be looking at the issues thematically. I think that's the most helpful way to do it. So I'll be considering scope and extent of the regs, timing, frequency, notice requirements for meetings, location of meetings, attendance requirements, that relates to members, public access, both for the meetings themselves and to documents, and finally, and very briefly, appointments. And I don't envisage that this will take more than around 15 minutes. So starting with scope and extent, the power for these regs came from Section 78 of the Coronavirus Act 2020. That section allows separate regulations to be made for local authority meetings in England, Wales and Northern Ireland. So the regs that came out on Saturday and the ones which I will be discussing only apply to local authority meetings in England. In fact, I think most of you are based in and do most, if not all of your work in England. So as they stand, these regs will apply to all those meetings until 7th of May 2021. I know there are also some of you from Northern Ireland tuning in today, including from government councils and firms such as Carson McDowell. As Reuben was saying, I was lucky enough to be called to Northern Ireland Bar last year, so I've been keeping a close eye on the developments on that front. But unfortunately, as far as I'm aware, no regulations have yet been made by the Department for Communities. So no change to the previous situation. But when they do come out, one would expect them to borrow from these regs. So I think this discussion will be useful for you too. And the same can be said for Wales. Some definitions before you begin. Crucially, local authority meeting, defined very broadly, as you might expect. A meeting of any of those above on bullet points. And local authority itself is defined, again, as you might expect, in Regulation 3, very broadly. Getting on to the juicy stuff then. First of all, timing, frequency of meetings and notice requirements. We'll look at timing and frequency first. You'll see in that first bullet, Regulation 6C removes the requirement to have an annual meeting. So don't need to have an annual meeting this year. And even if you have an annual meeting, it removes the need for it to take place in those usual windows. Regulation 6D confirms that principal councils, i.e. not parish or town councils, still have the power to conduct meetings even if they don't hold an annual meeting. That was necessary because the effect of the 1972 Act, the Local Government Act, unamended, i.e. before Saturday, was, and this is in paragraph 2 of Schedule 12, principal councils could only hold other meetings in addition to the annual meeting. So this amendment just confirms that you can have other meetings even if you've had no annual meeting. We then have Regulation 4.1, which is a very broad catch-all provision. It gives authorities basically unlimited discretion to decide unilaterally when and how frequently to hold meetings without requirement for further notice. Now, there is a question mark over exactly what that means. And I think, in my view anyway, that does not mean that local authorities can hold meetings without giving any notice to the public. What it means is that changes to the usual dates, days, weeks, times, frequency, etc. of meetings can be done unilaterally without needing to notify anyone of the fact that a change has been made. As I said, it doesn't stop you having to notify for meetings in the days immediately before that meeting. And as for those requirements, they are amended by Regulations 6E and 13 and also 16.4.5, and I'll just mention that in a moment. For principal councils, first of all, previously the requirement to post a notice at the authority's office was contained in the 1972 Act and in the 1960 Act there. Both with the same effect. Now, as far as the 1972 Act is concerned, Regulation 6E of the new regs now allows that to be done by publication on the website, and 13A allows that to be done, the same to be done with respect to the 1960 Act. See also, and this isn't on the slide, see also Regulation 6 of the local authorities, brackets, executive arrangements, bracket, close brackets, open new brackets, meetings and access to information, close brackets, England Regulations 2012, which also had notice requirements for example, committee meetings, and Regulation 16.4.5 of the new regs similarly allows those notices to be, for those meetings to be published on the website. So for principal council, it's pretty straightforward, just any notice you would previously have done now, just put it on your website. For parish councils and town councils, the position is a bit more complicated, and I think it's been, unless someone can correct me, been a bit of an oversight. Now, as far as the 1960 Act is concerned, that obligation can now be fulfilled by publishing the notice on the principal council's website. No problem there. But there is an obligation in the 1972 Act, set out there, paragraph 10.2a of Schedule 12, requires notice to be fixed in some conspicuous place in the parish. That, as far as I can see, hasn't been amended in the 2020 regs, whether it's an oversight or otherwise. But I mean, in my view, to be on the safe side, it appears that parish councils now have to do both fix a notice in a conspicuous place in the parish to satisfy the requirements of the 1972 Act, and also publish it on the principal council's website for the 1960 to satisfy the 1960 Act. Moving on to location of meetings. Before the 2020 regs, you could not transact business at a fully remote meeting. Very simple, that's the way present had been interpreted in that first bullet. Very simply, Regulation 5.1 of the new regs changes the position so as to remove any bar contained in legislation to holding a fully remote meeting. Therefore, all members can now be in different places and connected by electronic means. Pretty straightforward, so far, so good. But what happens if an authority's own procedural rules prevent remote meeting in some way or have some other unfortunate bar? Now, I've set out there what regulations 5.5 and 5.6 say. Jacqueline touched on them just now. Now, there are obvious, and just note the word, 5.5 is worded, I suppose it could have been worded slightly better, but with the time constraints, it's understandable. But if you just read 5.5 carefully, so there are obvious cases, if, for example, standing or procedural rules say the meeting must be conducted in the local authority offices, then 5.5 looks to make that restriction ineffective without a local authority having to do anything further. What about a more complex situation? So I thought it might be useful to look at a case study very briefly. I live in Weybridge, Surrey, so I looked at the rules of my local borough council, Elmbridge Borough Council. Rule 15 of their procedural rules, you can see what they say. I've set them out in that last bullet. They require voters to be present in the room. And I also note that the local authority in which I used to live, Islington, has an almost identical provision. So it may be a provision that is in many many rules, procedural rules. So what's the possible legal analysis here? And before I carry on, just to reiterate, this is not legal advice. This is just an academic discussion of the legal issues arising. So what's the possible legal analysis? Well, first, in my view, that procedural rule would likely be construed as requiring councillors to be present in the same room. Second, as far as I'm aware, there's no legislation on voting procedure. It requires certain voting procedures to be taken. Third, and therefore, it's likely that Regulation 5.1 does not bite. And fourth, and therefore, Regulation 5.5 does not bite to make that provision, that standing order procedural ineffective. Fifth, and consequently, it would seem that that procedural rule stands. So how do you get around it? Because there's no point of having a virtual meeting if you can't vote virtually. And I think the answer is you rely on 5.6. The safest thing to do is to amend the rule. And that can be done in a number of ways. The easiest way would be to remove the words "in the room," probably. Or you might want to make it more explicit in that specific wording to make it clear that virtual voting is acceptable. There is a metaphysical point here about how do you vote to amend standing orders relating to voting when the current standing orders do not allow virtual voting. But I'm pretty confident that it's still possible. Without getting into the details of it, the short answer is that not allowing voting in virtual meetings to amend these types of rules would frustrate the purposes of Regulation 5, and it would frustrate Section 78 of the Coronavirus Act. I should say we also had a question come in by email before the webinar started, and the question related to 5.5 and 5.6, and it said that the list in 5.6 doesn't include delegation of powers to officers. Does that mean standing orders related to delegation of powers must remain as they are until it is possible to hold a meeting in the usual manner? And I think the short answer to that is, well, you can do in a virtual meeting whatever you previously were able to do in a physical meeting. So if you're able to do that before, you can do it now virtually. The reason why it's not on the list in 5.6 because 5.6 is catering for new possibilities that were not available, open to local authorities before. So that's why it has to set out the fact that authorities can now make procedural rules, standing orders about remote attendance. The fact that it's not in that list that doesn't matter, frankly. You could do it before. So moving on. Member attendance requirements. Now we know that Section 85 of the 1972 Act requires members to attend a meeting at least every 6 months. And quite simply, Regulation 5.2 to 3, and 4 adds to it, 5.2 to 3 particularly, allowed for remote attendance where the conditions that you can see in those sub-bullet points are satisfied. So as long as the member can hear and be heard by other members, any members of the public entitled to attend, to speak, and any other members of the public attending, then that counts as attended for the purpose of Section 85. If practicable, then they should also be seen by others. But again, that's if practicable. So just being heard and being able to hear is sufficient for attendance. Perhaps the trickiest issue, then moving on to public access, will be attendance of the public. Now, the legislation, the previous legislation, well, still in force, in fact, invariably refers to meetings having to be open to the public, as in various pieces of legislation, which I've set out there in the first bullet. And the regs have simply clarified that this includes access through remote means. And you can see how the same formulation of wording has been used in regulations 13b, 14, 15, and 16 for that wording there. Now, what does that mean exactly? What is, in other words, what is the meaning of access to the meeting through remote means? You see in Regulation 3, it defines remote access, and it says it's in accordance with Reg 5.6c, and you can see that that's underlined wording is to enable them to attend or participate in that meeting. So it's not particularly clearly defined. Now, there are going to be all sorts of technological issues. What happens where the relevant member of the public can't get onto the conference, or for whatever reason can't be heard, or who joins but then gets cut off at the crucial moment? All those sorts of questions. I just put those out there for now without answer. I think Jenny will touch upon it and we can answer it more in the question and answer session. But the basic legal framework is relatively straightforward, but obviously there will be tricky issues when one gets into particular situations. Oh, apologies, that was the second slide I was supposed to go to. Moving on to document that comes in hand with public attendance, Regulation 15 clarifies that in relation to the 1972 Act, at least, a document being open to inspection or being made available includes publication on the authority's website. And the same clarification is also made in relation to the Executive Arrangements Regulations 2012. So basically, whatever documents you were physically allowing the public to inspect before, now just make sure that they are easy to access from your website. And finally, in relation to written records of delegated decisions, these can now also be published on the website, thanks to Regulation 17 of the new regs. Finally, on appointments, Regulation 4.2, the Ronsil provision does exactly what it says on the tin. Where an appointment would otherwise be made or required to be made at an annual meeting of a local authority, such appointment continues until the next annual meeting of the authority or until such time as that authority may determine. Thank you very much. I'll hand back now to Reuben and to Jenny.
Thank you very much indeed, Yaaser. We're now going to turn to Jenny Wigley. Jenny was a solicitor before being called to the bar in the year 2000. Her practice encompasses planning, environmental law and non-domestic rating. Jenny appeared in the important recent Supreme Court case of Wright and the Forest Dean on what constitutes a material consideration in planning decision-making. And Chambers and Partners notes that she is someone who carries out forensic and sound analysis of knotty issues. She is addressing the practical implications for and the risks of making decisions during this emergency period. So Jenny, over to you.
Thanks very much, Reuben. Good afternoon, or still morning. Good morning, everyone. Yes, I'm going to be dealing with the drawing together some of the points that have already been made by Jacqueline and Yaaser as to the practical potential problems and legal risks of making decisions during this difficult period. There we are. Let me just go back. Just getting the hang of the slides. So just drawing together some themes then of where legal risks could arise from. Obviously, there's just the immediate difficulty of ensuring compliance with the letter of new regulations in these difficult circumstances, and the need to consider them quite closely. Allied to that is the need to correctly understand the extent to which those regulations do, and importantly, do not displace existing statutory requirements. And there may be some need to look quite closely at Part 3 of the regulations, which sets out the consequential changes to other statutory rules. Allied to that is understanding the relationship between the regulations and their effect on the Council's existing standing orders and published procedures. And both speakers have already touched on Regulation 5.5, and I'll be coming back to that, but it's important to understand the limits of that, what existing standing orders can be set aside and what standing orders would need to be amended if they were going to be changed. And then, of course, it's very important not to forget the need to observe other public law duties, particularly the common law requirement of fairness, but also duties under the Human Rights Act and the Equalities Act, particularly when considering public participation. Just generally speaking, as a rule of thumb, it's important, in my view, for councils to ensure as far as possible that changes are not seen as reducing public scrutiny, participation or transparency. And that should be really in the back of the mind of anyone making decisions in relation to changes of procedures in this manner. So just looking then at the specific areas of potential risk, and I've listed some there, which I will go through in a bit more detail. Notification of meetings, technical issues, which covers a broad range of potential problems, involving the public and also excluding the public for exempt and confidential information, public speaking at meetings, site visits and how that affects planning decision making in the current circumstances, making documents available, and reliance on delegated powers. So starting then with public notifications of meetings, as Yaaser has already touched on, Regulation 4.1 of the new regs does appear to be very permissive and broad. At first sight, it appears to allow changes to dates of meetings, movement of meetings, cancellation of meetings without further notice. But on closer inspection, we think it probably means that a council can make a determination to change its schedule of meetings, to change its frequency without further notice, but that each actual individual meeting still has to comply with its own notification requirements. And those are set out in the provisions I've set out in the second bullet point. Regulation 6 of the 2012 regs relates to notice of meetings, committee meetings and the like, normally 5 clear days, but can be on short notice as long as that notice is published on the website. And then the paragraph 4.1a of the Schedule 12 of the 1972 Act requires 5 clear days for whole council meetings. We think that those notification requirements still would need to be met, notwithstanding Regulation 4.1a. And of course, in any event, it's important, as I said before, to observe common law requirements of fairness and possible legitimate expectation. For example, legitimate expectation can arise from a statement of community involvement, which may set out the council's intention to notify objectors to a planning application of the committee meeting. And if that notification doesn't then happen, there could be, and as a result, the objector misses out on attending the meeting, albeit remotely in the new world, then that could be a breach of legitimate expectation. So it's also important to check your statement of community involvement and any other public procedures published on your website that may need to be met in terms of notification. broadly speaking, obviously there's huge potential problems with the new technical procedures that would need to be brought into place. Which platform do you use? I've already seen in one of the questions, which I'm not going to attempt to answer now, but how does that interact with GDPR regulations where the data of the provider is kept? Do members have the technical means and ability to access remotely? Do they need some training? I've seen somewhere that I think it's the PAS guidance suggests having a whole previous committee meeting run as a dry experiment. So going through a previous planning committee, have planning officers playing members of the public, running through it in its entirety to spot what potential problems might arise and how it complies or doesn't comply with Regulation 5 of the new regs. There's obvious potential problems that could be caused by drops in connectivity, particularly the conditions in Regulation 5.3, which are all required to be met to mean that a member is said to be in attendance of the meeting at any time. So if the connectivity drops for that particular member, he or she would not be in attendance because he or she would not be able to hear or be heard during that period. So there's obvious issues there about ensuring that the meeting is quorate without that member in attendance. But then there's potential problems, of course, if that member then votes and has missed an important part of the meeting. So all those sorts of issues would need to be considered and set out in particular protocols and procedures to guard against potential breaches of Regulation 5. And it may need to be a recess of the meeting, a repeat of some aspect of it, or in a particular difficult situation, an abandonment and postponement when those technical glitches hit. Those sorts of problems are amplified, of course, when you have involvement of the public. And for meetings to be open to the public, as Yaaser touched on, it has to be accessible to the public through remote means. That's defined in a number of places in the regulations, accessible through remote means. Now, what happens if some members of the public, some areas, perhaps not in the southeast so much, but in other more remote areas, some whole areas of local authorities may not have good enough remote access, good enough broadband to make it accessible, particularly by video conferencing? Then you'd have to think about having telephone access or other means and ensuring that it is accessible to the public. And of course, considering duties under the Equalities Act to ensure that people with protected characteristics are not unduly prejudiced or discriminated against by the means that you choose. There's a potential minefield there in terms of ensuring it is open to the public. And of course, there's need to consider fairness. In these circumstances, the sort of standard of fairness would take into account these circumstances, but of course it still needs to be equally fair to all potential participants. There's no need for it to be the most fair procedure. Someone could argue, well, it's more fair if everyone attends in person. That's not the test. As long as it's sufficiently fair and equally fair, then the common law requirement of fairness should be met. It's sensible, as I said, to put in place basic protocols and procedures to ensure equal and fair access. Again, as I said before, there is a potential problem with drops of connectivity at crucial moments, and that would need to be dealt with in your procedures and protocols as to how to deal with that. One thing that is a particular problem, and it's perhaps more of a problem when I come on to the next slide, is that the test of a member being in attendance under Regulation 5.3 includes to be heard and to hear any members of the public entitled to speak at the meeting. Now, it's any members entitled to speak. So arguably, even if they're not in attendance, if they're entitled to attend and for some reason couldn't, or decided not to that they didn't want to attend, then arguably a member would not be in attendance because they could not be heard by that member of the public who was entitled to attend in order to speak. Similarly, if they could not be so heard by members of the public attending the meeting who are actually in attendance, but for some reason there's a drop of connectivity for that particular member of the public, does that affect the definition of whether the member of the council is in attendance? There's some really potential knotty issues there, problematic issues as to the definition of a member being in attendance and how that interrelates with the public attendance. As I said before, it's not just the involvement of the public, it's excluding the public, as everyone will be aware that there's potential need to exclude the public if confidential or exempt information crops up and needs to be discussed. Issues around considering how to re-provide public access when that discussion has concluded, and how to ensure that your technical platform, your telephone access or whatever, can be controlled to exclude the members of the public at the appropriate time. And again, there's a similar problem that arises under paragraph 5.3c and the definition of whether a member of the council is in attendance. If members of the public are excluded during those periods, those public would not be heard or be able to hear the members of the council. Strictly speaking, on a sort of forensic analysis of the statutory words, that would mean that the member of the council was not deemed to be in attendance of the meeting during those periods. I'm sure the courts would perhaps take a bit more of a sympathetic and broad purposive view of the legislation, but it's just an example of some of the technical glitches, both in terms of the virtual access, but also in terms of how the wording of the statute's been framed in this emergency period. There are potential problems there. Public speaking at meetings, if you already have procedures allowing members of the public to speak at, say, planning committee meetings, those would continue to apply. There's no statutory requirement, as you probably know, for public speaking at meetings, but if you already have procedures in place and a legitimate expectation that people will be able to speak, then that would still need to be followed. Regulation 5.5, which disapplies procedures and standing orders, only does so in relation to those standing orders requiring real attendance rather than a remote attendance. It doesn't affect to change procedures and rules about, for example, public speaking at meetings. So unless those rules and procedures are changed, they would still need to apply, and then you would need to follow Regulation 5.3b, which requires live attendance, effectively, of those persons entitled to speak. It's not sufficient for a pre-record to be used in those circumstances, or for it to be reduced in writing. However, of course, it is open to a council to change the rules and change their own protocols to reduce either reduce public speaking entirely or to change how public speaking will apply. And in those circumstances, then there would not need to be live attendance. Of course, again, technical point, ensure the technical tools are in place to allow public speaking without disruption of the meeting overall, and to enable the public speaker to be muted through the rest of the meeting, so that there won't be difficult interruptions. Another possible problem, obviously, at this current time, are the need for site visits, particularly, of course, in the planning field. The regulations do not deal with site visits, so existing council procedures and practices will continue to apply in terms of what is required. I do sort of slightly facetiously say that arguably site visits are currently unlawful under the coronavirus restrictions regulations 2020, and I'm thinking there particularly of the restrictions on people leaving their homes. But of course, people are allowed to leave their homes with a reasonable excuse, and there's a non-exhausted non-exhaustive list of what a reasonable excuse is. And under 6F, it includes travel for the purposes of work, or to provide voluntary or charitable services where it's not reasonably possible to do that from the place where someone's living. And clearly, I would suggest that site visits would fall within that reasonable excuse. However, of course, it may well be impractical or undesirable to have site visits in the current circumstances, particularly given the government guidance on social distancing and the possibility of vulnerable people ordinarily wanting to attend the site visit, and of course the issue of other people being either self-isolating or being ill and unwell. So it may well be that site visits are simply not taking place and cannot take place at the moment. That of course leads to its own problems in relation to meetings. There's nothing in the regulations which says gives anyone a carte blanche not to have site visits. And of course, where there is a complicated or particularly visually sensitive scheme, it leads to its own risks if members misunderstand the physical context, or heightens the risk of them being inadvertently misled by the written material. And of course, as I said before, if there's an expectation that for a certain type of application there would be a site visit, there would need to be an amendment of that existing procedure to enable a decision to be made without such a site visit. Availability of documents. This isn't perhaps such a tricky issue because councils have for a long time now been pretty diligent about ensuring that all documents related to particularly planning applications are posted on the council's website. But there are obvious fairness requirements to ensure that they are easily accessible and in a logical place on the website. And Mr. Justice Lindblom, as he then was, said in Kendall and Rochford, that was, albeit that was in the local plan consultation context, that one needs to beware of over-reliance on a website. Now, of course, here there's a complete reason to rely on a website in the current circumstances, but it's important to make sure that the website is accessible, the page can be found, and particularly that maybe particular people, particularly objectors, particularly those with a particular interest, may need to be pointed to the website, pointed to new information on the website, rather than relying on them just looking at it as and when. Background papers are particularly important. There is a duty to make background papers available for inspection, and the new regulations make clear that that can now be done by putting the background papers on the website. Background papers, as you'll be aware, are those background documents which can be internal or external emails, reports, or expert information that are materially relied on in an officer's recommendation. Those still need to be listed, and the background papers, I would suggest, need to be on the website and easily found to ensure that the public are able properly to participate in the decision making. And I highlight there two fairly recent cases as illustrations of what happens if those background papers are not made available. And in short, it means the planning decision can be quashed. Then the issue of delegated powers. Now, obviously, at the moment, it's a potentially very attractive solution to delegate much more decision-making to officers, as it avoids a lot of the practical problems and legal risks of holding virtual meetings. But it's very important to be aware of bending or stretching those powers beyond their limits, and ensuring that all decisions are still made within the existing delegated powers and not beyond those powers. If there is a need to extend those powers, then one would need, I think as Jacqueline mentioned, to consider expressly amending them. So to hold a virtual meeting to make a decision to amend those powers, or to go through whatever procedure is set out in the Constitution to amend those powers. A decision to amend should, of course, always be made on proper considerations, taking into account relevant factors, and as I said before, must not be seen as being an opportunistic way of preventing public scrutiny and participation. So a blanket delegation of all planning decisions may be open to some challenge potentially, perhaps under the Human Rights Act, if all considerations have not been taken into account for public participation and for those of particular public affected by reason of impacts on their family life or their property. Of course, when expanding delegated powers, it's crucial to ensure that each delegated decision is made observing the strict legal requirements. There's the 2014 regulations, which I think it's open decision making, openness of local government bodies regulations 2014, which require a record of the decision to be published and the reasons to be included. That can now be done on the website. That's been specifically provided for in the new regulations, but it's important to ensure that the reasons are clear and full in terms of explaining how the decision was reached. And that's particularly important when larger applications are decided in this way. And I note there the two decisions of the High Court, Mrs. Justice Lang in the Rogers and Wickham case, which suggested that where an officer's report is relied on as a record of reasons, that should be subject to a higher standard of scrutiny than officers' reports are subject to when they're just considered as advice. If they are intended to be a record of the reasons, then they needed to be subject to the scrutiny of the standard of reasons required in South Bucks and Porter, for example. And the very recent decision in Gar and Baber upholds that decision, notwithstanding an intervening other High Court decision, which perhaps suggested that wasn't right. Of course, it's always important with delegated decisions to ensure that the actual decision maker, not just the officer who's providing the recommendation, but the actual decision maker is provided with all the necessary information and the background papers to properly determine the application. And I think that's the end of what I needed to say. So I'll hand back to Reuben. Thank you.
Thank you very much indeed, Jelly. We're going to turn now to the Q&A session, and I think that we're all going to appear in video form in front of you all, so brace yourselves. Yeah, here I am. This is where you all get to see inside our homes, which is quite an unusual experience for a barrister, but anyway. We've had a number of questions. Thank you very much for sending them all through. We're going to try and deal with some of the sort of general themes now. There are some quite specific questions that we'll probably deal with in follow-up rather than attempting to answer now. For the first broad area of questions really relates to the delegated powers issues that Jenny just touched on. A number of people are asking questions about what scope there is in law for the delegation of powers to officers and what restrictions there are in practice on officers taking decisions, and indeed whether or not taking a decision by way of delegated powers increases the risk of judicial review. Now, who wants to step up and answer some of those?
I'm happy to do so. Shall I get it over with? Yes, the scope of delegated powers in terms of the statutory scope is very wide, as I think Jacqueline touched on in her presentation. Under Section 101 of the Local Government Act, most decisions, particularly planning decisions, for example, can be delegated to committees or officers in equal measure. So in terms of legal restrictions, there's no, for example, legal limit on what types of planning decisions can be delegated to officers. But what would need to be considered is the council's current constitution and rules and scheme of delegation. And that would need to be followed to the letter unless and until it has been amended by a new decision taken, again, in accordance with the constitution to amend those delegated powers. As I said, that can be done, but proper considerations would need to be taken into account and any potential objection to reducing the scope for committee meetings would need to be considered. And as I said before, I think there is the potential for more legal challenge in delegated decision making. But also there's a potential avoiding the virtual committee meeting, and some of the glitches that may occur through that would be avoided. So it might maybe swings and roundabouts. But so long as the delegated decision maker is the person specified in the delegated powers and is provided with the full information from the consultees and background papers, and then provides reasons for his or her decision, and those are published, then there shouldn't be any particular heightened risk. That's my view anyway.
Yes, I mean there's no different standard applied by the courts in terms of the quality of the decision, as I understand it. It would be the same as is applied in any judicial review of a committee decision. But it's just there may be some procedural aspects or some limitations on the extent of the power that an officer may have in terms of their delegated scope that might give rise to risk of challenge. But as you say, as long as councils follow their scheme of delegation carefully, those risks should be mitigated. The next question that I've written down, a broad theme, really turns on some aspects of the planning system. We've been asked about whether various aspects of the planning system still continue to apply. First of all, we were asked about the time limits for decision making on applications, and whether those continue to apply, and what the consequences are of that. Certainly, my understanding is that there's been no change to the relevant time limits in the legislation, and that the time for determining applications is still in effect. And that means that if you go beyond the particular time limit for your type of application, then you can appeal for non-determination, whether that's something you really want to do in the present circumstances, given PIN's stance, is another matter. But of course, you can also agree before the expiry of the period an extension of time with the local planning authority. So that I think deals with that question. There's a linked question about the time limits for challenges to decisions, either through challenges to appeals, but decisions by PINs or Secretary of State, or indeed time limits on judicial review, and whether whether there have been any extensions granted on those, and what the approach that the courts would take about time limits. Anybody want to take that one?
Yeah, happy to. The courts set out guidance that obviously in the current circumstances there may be more circumstances in which extensions to the time limit, 6-week time limit, might be granted. But I mean, that is caveated by there has to be a good reason why the 6-week limit has not been followed. So it's definitely not, current circumstances, not carte blanche for sticking in your JR 8 weeks after the decision. But I think it's fair to say that the court will look more carefully at extensions of time than they would previously. But there's no technical change to the 6-week time limit.
Yeah, the only caveat I would put on that is in relation to Section 288 challenges. So statutory challenges to decisions by inspectors or the Secretary of State on a Section 78 appeal. There is a statutory 6-week time limit which is absolute. And there is no means for the courts to extend that, and so that time limit is still in force, subject to any amendment in the legislation that we may get in the coming weeks. Okay. Another question we've been asked relates to whether an audio feed would be sufficient in and of itself for a local authority meeting to be considered to be open to the public. So if you just did your meeting without a video link, and if a member of the public simply had a telephone line to call in. Anybody want to take that one?
I'm happy to pick up on that, Reuben, subject to any conflicting views there may be from other members of the panel. I mean, my sense is that the courts at the moment are working on the basis that it's sufficient for hearings to still be technically open to the public, where it's being done by a telephone hearing, but where the notice of that telephone hearing has been published on the the court list in the usual way, with information given as to how members of the public can dial into that telephone hearing if they wish to do so. So I think, subject to seeing anything more explicit about it, I've thought that provided there was public access available, even if everybody was only participating by phone, that would seem to, I suppose, tick the box. Whether that is the best way of dealing with any particular case may be another matter.
And just to add to that, I think that must be right, because we've seen that attendance by a member can be satisfied simply by hearing and being heard by others. Doesn't require a video feed. If you look at 5.3, and then when you look at 5.6, if you look at the definitions of open to the public, it includes, or if you look at 5.6c, it refers to telephone conference as well as video conference. So I think it must have been envisaged that that telephone by itself would be okay.
Yeah, and just to add to that as well, I think some confusion could creep in, because the reference to, the definition of open to the public in various places in the regulations says includes access to the meeting through remote means, including but not limited to video conferencing, live webcast, and live interactive streaming, which does suggest that what is envisaged includes some type of video, some kind of visual virtual conferencing. But of course, those words are including but not limited to. So that would allow for audio participation. And as you just said, Yaaser, that it seems to be what's envisaged as a minimum in Regulation 5 to be so heard, and where practicable to be seen. So I think audio would be sufficient.
Yes, I mean, I was thinking, for example, of somebody who may want to participate as an objector to a scheme, but who isn't particularly IT literate, or doesn't have access necessarily to a webcam, and would want to simply dial in on a telephone, because that's the nature of the technology that they know how to use. Seems to me that it would be remarkable if that person would be excluded from participation in some meaningful way via the process adopted by a local authority. And local authorities will need, as Jenny emphasised, in relation to their public sector equality duty, to have regard to that sort of factor. Okay, we've had some other...
Reuben, just on the question we're talking about, someone's asked, well, what about if you have a telephone call, what about if the visuals are particularly important to the application? I wonder if anyone has a view on that.
I mean, I think for my part, if it's the case that the planning system is going to operate, for example, via documentation that's only available on the web, and that is considered acceptable by statute, then it seems to me that offering that kind of level of access to documentation and to visuals, will be sufficient. And whether somebody needs to see precisely what the presentation is that's being put to members on the screen, as long as what is being put to members on the screen is already available on the web, I think is unlikely to be problematic. But that's my thoughts on that. I was going to move on to two or three other points about the planning system that people have queried. We've already talked about site notices, and people are asking whether they're still required, and how can they legally be put in place, for example, and what's the point of putting them in place at present. The second aspect is about, and this is more interesting, about some of the requirements, for example, in relation to EIA applications for planning permission. There's a requirement to place an advert in a newspaper circulating in the locality, and whilst you might be able to provide an advert to a newspaper, is it really circulating in the locality if it's not being distributed? There's that point. And there was also, I think, another point raised in relation to some documents, for example, environmental statements. There are provisions that require documents in applications to be made open to inspection at the local authority offices, and what happens about those. Does anybody want to kick off on site notices? And then I've got some thoughts on newspapers and documents available for inspection.
Shall I go on site notices? Well, I think, again, site notices could be legally put in place, notwithstanding the coronavirus restriction regulations, because, so for example, under the EIA requirements, where there's an absolute requirement to put in place a site, I think there is an absolute requirement to have a site notice for EIA type development, then that would be a legal obligation. And one of the reasonable excuses listed for leaving one's home is to comply with a legal obligation. So they could lawfully be done. Of course, whether they serve any useful purpose is another question at the moment, when people aren't generally walking around very much or driving past things to see them. But to be safe, it would be sensible to put one in place, I would say. Having said that, of course, if one isn't in place and the person is, well, I think the situation where a challenge would happen would be where someone hasn't been notified of an application and there wasn't a site notice in place, then there could be some difficulty. So I would say that it would be sensible to comply with that obligation, even if it doesn't really serve any useful purpose.
Right.
There's a case in, there's a case, the Gerber case in the Court of Appeal, which I was involved with in, made clear that once a council has complied with its notification requirements, statutory requirements, the fact that someone hasn't seen the notice isn't a basis for seeking an extension of time for judicial review, for example.
Quite. Okay. Well, I mean, on site notices, I think that's that. In terms of the requirement to place an advert in a newspaper circulating in the locality, I mean, it's pretty clearly arguable that if a newspaper isn't being distributed, it is not circulating in the locality. And it's certainly a concern of mine at the moment that's an aspect of the process, particularly in relation to EIA development, that we probably need some clarificatory secondary legislation on to address. For my part, that is a concern. We were specifically asked about the requirements of Regulation 23 of the EIA regulations, which requires an ES to be available for inspection at the local authority offices. And I took the time whilst some of you were speaking to just remind myself of that article. And in fact, that requirement to make it available at the offices is only one way of satisfying the publicity requirements in respect of ES. There's or used in Regulation 23. It says all the ES can be posted pursuant to Article 15 of the Development Management Order, and Article 15.7 allows for an ES to be posted online. So it looks to me as if an ES you can get away with it not being physically available at the offices of a council. But again, that's something that we definitely need clarification of via secondary legislation. Hopefully we'll get that soon. Okay. Anybody else want to add to those points, or shall I move on to the next point? Everybody's looking very quiet. Okay, I'll move on. The next aspect that I've got on my list is that there was a question about how can consultants or developers ensure that they get to participate at planning committee meetings. Anybody got any thoughts? I mean, it seemed to me that it depends on the standing orders that are in place at the time of the committee meeting, and if those have been, there are some authorities that already don't allow participation by either objectors or proponents of schemes at committee meetings. But it seems to me that if a local authority wants to change its standing orders, it's able to under the new regulations. And they can either change it to limit the involvement of third parties, such as the applicant or objectors, to zero, or they can require something in writing. They might require a particularly limited involvement, maybe down to a minute or two. It's entirely, it seems to me, up to the local authority, subject to the requirements of fairness, of course. That sound about right to everybody? There are smiles and nods, which is always reassuring.
Reuben,
Okay.
Sorry, Reuben,
Yeah.
I was just going to add on that, is that certainly a lot of the guidance I've seen floating around is that as we move from hearings to virtual hearings, that in terms of, I was trying to minimise fairness concerns or potentially minimise any sort of legal risks that may emerge. Obviously, it would be quite good to try and mirror in your remote proceedings the practices, in broad terms, that you're adopting where proceedings are actually being held in person. Now, obviously, the best can't be the enemy of the good, but that seems to me a sensible starting point, which is if your procedures do currently allow for participation, albeit on prior, having signed up previously to say I want to speak and limited to certain times, if a way can be found of providing for that in the virtual world, then that would obviously be probably the best case scenario.
Okay, thank you. Now, another point that's been raised is that some authorities are saying that they will only deal with applications and take decisions once the current crisis is over, and people are asking what can be done to force them to start to implement the sorts of changes to their procedures that we've been discussing this morning, in order to get decision making running again. Anybody want to take that one?
Yeah, I've tried to answer some of these in the question and answer box, and I think this is probably, in my view, is that if you essentially had a blanket policy, I don't think there's a positive obligation to conduct time by remote meeting, but if there was a blanket policy that said we're not listening or hearing or validating or having a meeting on anything until July, that depending on the good reason, that policy of a local authority could be open to question. I mean, that's having not thought about before. That's my initial view. I don't know if others agree with that.
Well, I mean, for my part, it seems to me that if you've already got your application in and nothing happens to it, you do have a remedy in the form of a non-determination appeal, albeit not a particularly attractive one, I dare say, for most people. If your application isn't being validated, then again, there's also a validation appeals process too. Again, not particularly attractive. But I think in a more practical way that different people have reacted to this crisis in different ways, and some more extreme than others. And it seems to me that once local authorities around the country start to take tentative steps towards decision making, we've got the example of the Royal Borough of Kensington and Chelsea leading the way this evening with their committee meeting. I think they're to be commended for that. As more local authorities start to take those steps, and people see that it can be done, and obviously it needs to be done, then I think there'll be a growing amount of pressure and a growing amount of knowledge about how to do it successfully that should persuade those who are more reluctant to take steps to move forward. That would be my hope, anyway. Anybody else got any thoughts? Okay. Fine. I think it's nearing 12:30, and we've got loads and loads of questions. I think there are still 39 outstanding on my list, but I think we've probably come to the end of what we can usefully say at this stage. We will be responding to the questions that are still outstanding in our follow-up. And so I hope that that this afternoon has been useful. We've demonstrated at least that some of Landmark can use the technology. We wish you well. We wish you that you all stay healthy and stay safe. And we look forward to working with you all in the near future. Thank you very much indeed.